SJC-12438 in the matter of an impounded case.
Good morning, Ms. Weisberg.
Good morning, Your Honors. To please the court, I'm Attorney Alice Weisberg, and with me is Attorney Courtney Dunn. We represent the respondent appellant, whom, with Your Honor's permissions, I'll call John Doe in this matter. Your Honor, Mr. Doe was 19 years old at the time he was experiencing his first psychiatric hospitalization and first psychiatric treatment, both of which are at issue in this case. Mr. Doe is appealing pursuant to General Laws, Chapter 123, Section 9A, which gives him a statutory right to appeal involuntary commitment, involuntary treatment orders. Mr. Doe, in this case, is challenging the decision of the Appellate Division of the District Court, which dismissed his case as moot, given that Mr. Doe had been discharged from the hospital. We challenged that decision of mootness in our matter before you. The district court also found, based upon your decision in matter of Inel, for which we had stayed this case because the issues were the same, is a person's fundamental right to due process denied or violated by the denial of a first request for continuance in order to obtain independent medical examination and prepare a meaningful defense. The Appellate Division mirrored, as the appellee calls it, the decision, this court's decision in matter of Inel by finding the matter moot, but also acknowledging that his fundamental right to due process was violated by not granting the first request for a one-week continuance. We believe that this case is very distinguishable from Inel, and one of the primary reasons of that is Inel was decided before the enactment of General Laws 123, Section 36C. He was committed on November 16th, I believe it was, of 2014, whereas Mr. Doe was committed subsequent to the enactment of General Laws 123, Section 36C. And thus, I believe that it requires a new mootness analysis and can't just rely on the cases that occurred before the enactment of the statute to just sort of dispose of the cases moot merely because the person was discharged. We argue, Your Honors, that to find a case moot because the person has been discharged moots out virtually every case, because the legislature knew when they enacted the statute, and enacted 9A, which I believe was in the 80s, that the period of commitment relative to the time of appeal is very short. So first commitment is for up to 6 months, and as you heard, it's often much shorter than that. Subsequent commitments can be up to a year. It's often much shorter than that. And so almost every case, the person is discharged from the hospital prior to the appellate process being completed. And so it would make the statutory right to appeal illusory if we found that because they're discharged from the hospital, they no longer have the right to appeal, that there's no remedy that they can be provided, finding that because they have their liberty back and they're no longer subjected to the orders of the court that involve involuntary treatment, that they no longer are subject to the orders of the court. I submit to you that I believe that 123 Section 36C changed that dynamic dramatically. I also believe that even under the regular analysis of mootness, that the case was not moot despite discharge because he continued to have ongoing legally cognizable interests in the matter. And I believe that one way in which we can analyze mootness is...
I mean, what, for example, I read the federal case one of you cited about stigma, and how does stigma play out in this area given these records are confidential? I'm trying to understand that.
I appreciate that, Your Honor. I think it's, well, you said it exactly right. The records of commitment are confidential. 36A makes the records confidential. To some degree, the discretion of the court, criminal complaints and such can be viewed, and these cases can be listed on the criminal docket. And so there are exceptions to that. But also, under Kirk v. Commonwealth, the court hearings themselves are open. They're open to the public. And as a matter of fact, Section 5 of 123 actually requires that the court notify the nearest relative or guardian of the time and place in the commitment hearing. As we've seen in the news lately, there's nothing to keep people from disclosing the fact of the commitment. That anybody who's in the courtroom, anybody who knows, as we see, like I say, in the press lately of the very unfortunate incidents that have happened with people being released, in the case before us is one, it took me a minute, literally a minute, to find out who the defendant in that case was, even though he's in the briefs.
Well, but there's a lot going into that can't be controlled, such as neighbors and other people who know the person. I mean, could never be a way to completely quiet that down.
Well, that's my point exactly, Your Honor, that though the records, the court papers are kept private, there are a myriad of other ways that this information can and is disseminated. It's in their medical record. And so their medical record can be viewed by any number of medical professionals, and I would dispute the contention of the appellee that this information isn't used in future commitment proceedings, because it is often. It could also be the same court. Often the people go back to the same hospital, so the same judge actually knows that they were committed previously. The fact of a commitment can be used in abuse prevention order matters, harassment prevention order matters, where hearsay is admissible. They can be used in guardianship matters, where the issue of capacity is an issue. It can be used in care and protection and termination of parental rights. The fact of the commitment stigmatizes the person.
But the real harm that you portray in your brief is that the reviewing court has said, because of NL, these are automatically moot. And if that's the case, you'll never reach the merits. And a court could, in its discretion, decide to hear the merits of the case.
I'm sorry, say that last
A
part.
court could decide to hear the merits. They don't have to, but they could, right?
A court certainly could decide the merits of the case, Your Honor. I would argue that courts generally decide merits of case when there are sort of unique issues, and that it can be a prospective kind of decision. For all those people who don't have that case, but who have been wrongfully committed and whose rights have been massively curtailed, I believe that they too deserve a remedy. And that remedy is the vacating of the underlying orders that were entered wrongfully.
And what you can't do is to read NL to say that we're going to automatically moot these cases after they're released.
I think that's correct. I think that would be correct if 36C had not come into play, because I think that mootness deserves an individual case analysis of what harm is that individual person suffering. But certainly with 36C and the requirements and prescriptions of 36C, I think it flips the mootness analysis sort of as it's understood today, that upon discharge, you no longer are suffering any harm. I think 36C puts an end to that.
NL didn't do any. In NL, there was no argument as it related to mootness.
That's correct.
Neither side was contesting it. Just said that it wasn't likely to reoccur.
And that's correct, because at that time, it was an issue of first impression, and they didn't need to fight the mootness fight. It wasn't that case. Right. Knew that we could get before the court because of the issue that was involved, that issue of first impression that was clearly likely to recur. And so that wasn't a case about mootness. That was a case about due process. This case more addresses mootness sort of head on. and it's from my perspective, the sua sponte nature of the way in which the appellate division dismissed the case without argument, just 2 days after NL came out, saying, we lift the stay, it's moot because NL said the case was moot. And I've cited a number of cases in my brief that the appellate division has mooted out. And subsequent to that time, there have been quite a number more that are being rendered as moot because the person has been discharged.
So are you saying that every case is not moot, then? I take it you're flipping it, so no case is moot,
I think with 36C in place,
even if I don't want a gun?
I'm sorry?
I found the 36C stuff a little artificial. It's, there's no indication this person wants a gun, has any interest in a gun, nor do we necessarily want him to have a gun. But I take it your larger argument is that none of these cases are moot because they really have so many collateral consequences. Isn't that really what you're arguing to us?
My overarching argument is certainly that these cases should not be moot because the person, first of all, my understanding of the case law is that when fundamental rights are involved, that the cases deserve a look. They deserve review on the merits because we've subjected.
That's once they're released, it's not there are no fundamental rights. It's the collateral consequences, right? I mean, no one's being held. They're released. So it's really these other consequences, the stigma associated with one of these things, potentially the firearm issue. I don't know what others there are. Guardianship, you say, the fact that you may end up before the same judge with another mental health issue.
They also go on a national database, in the criminal justice database, the National Instant Background Check, and
They go into a national database, again, for firearms or for other purposes?
well, the database collection is for firearms, but it also has access to the Attorney General. The Attorney General's office gets the information. The Federal Attorney General's office gets the information.
But again, for guns or for other reasons?
The intention is the background system, and it's regarding gun laws. But I would argue that there's really nothing to keep someone who has access to that information to use it in different ways. I don't see anything in 22G, in 18 U.S.C. 922, that requires the collection, or in 36C. And the fact that someone could feel harmed, not just, well, let me address the gun issue very briefly, because this isn't sort of a gun rights case. That's not what we're here about. But it is a fundamental right. And as a direct result of this wrongfully entered order, I apologize. This young man, who was 19 years old at the time, is deprived for a minimum of 5 years to a right to which he would have been entitled had he not been wrongfully committed. The other piece of that, Your Honor, is that because of the wrongful entry of commitment and involuntary treatment, he's on this database listed as someone who has been found by a court, presumably with due process of law, as being both serious mentally ill and dangerous. And I believe that has an incredible internal impact as well as external impact. And that we have a duty to say, we got that wrong. Even though you're released, we got that wrong, and we're going to undo the harms that you are suffering or that you might suffer because we got that wrong, that you deserve to have that order vacated. We're going to make you as whole as we can. We can't give them back the liberty they lost. We can't take away the treatment that they received, perhaps against their will. But we can say, we got that wrong. Your rights, in this case, to due process were violated, and we're going to make sure that you don't experience any of the collateral consequences that we argue actually do befall the people. We believe, in fact, and I would argue certainly, that the deprivation of a fundamental right without due process is a harm in and of itself. It is not a speculative harm. Whether or not the person chooses to use their fundamental rights, I believe, is not the basis for the analysis. The analysis should be, has the person been wrongfully deprived of a fundamental right or of rights, period? We don't know. He was 19 years old. He can't possibly get his rights back or get his name off that list, off the database, for a minimum of 5 years. And then he has the burden of returning to the committing court, which I say inherently links it to those underlying orders, because only the committing court, no matter where he lives in the country, he has to come back to that committing court, and he has the burden of proof now to show that his disabling condition, quote unquote, has been treated well enough, and there are various criteria for that, but that restoring his rights would not be essentially against public interest or lead to a dangerous situation. That becomes his burden, a burden he would not have but for the wrongful commitment. That is now his burden, so he has to travel back. This gentleman's from New Hampshire, but let's say he lived in Florida. But he decides that he wants to hunt. He wants to shoot clay pigeons or whatever it is, skeet shoot, that he wants a firearms license for whatever reason. He may wish to become a security officer. He may wish to become a police officer. These orders were entered wrongfully. His fundamental rights were violated then, and he's continuing to be deprived of his fundamental rights. There are many other consequences. Yes, sir.
I think your time is up, so thank you. I think your time is up,
Oh, thank you.
so thank you. Ms. Hall? Or Ms. Garrity Hall, I don't know.
Ms. Hall is fine.
Ms. Hall's fine, okay.
Good morning, Your Honors. If it pleases the court, Diane Garrity Hall on behalf of the appellee, McLean Hospital in this case. And I want to be very brief and just say two things. I think, again, as counsel is raising the issue of mootness, I think that's really what, as I see, what she's trying to raise here. And I think this court has done a very good job of setting forth when matters are technically moot because of a discharge from a mental health facility in these types of cases, when they're moot and when they should be decided. And the case law is very clear. It's been almost 20 years in the mental health field that this body has decided cases and looked at these cases in the Newton-Wellesley case, the Bournewood case, and has set forth factors and criteria for when cases can go forward. And you have heard cases, you do hear cases, and not every case is moot, as counsel says. And I think to turn and look at Chapter 123, Section 36C, which is the registry, the gun issue, to then turn that into all of these cases now become not moot, never moot.
How about the stigma? I mean, the feds seem to treat this differently, right?
So I agree with you, and that's something I've been wrestling with in reading the cases as to exactly what that stigma is. And I think, there's stigma for mental illness and there's stigma for commitment. And I don't know that anybody has distinguished between the two, and I don't know that there's a difference.
It's a pretty big difference, right? To be involuntary, to be committed to a hospital, I mean, that's something you carry with you forever, right?
Well, depending upon the illness, there's a lot of patients who never even remember that they went through the process.
Well, they may not remember it, but that's a whole nother story if you don't remember it.
Well, again, I think that, again, there's a reason why the commitments are being sought, because there are issues of illness and dangerousness, and that's the reason why somebody's being kept in the hospital. I mean, some of the numbers and the figures that the Department of Mental Health have put out are very interesting. There's only 4% of all admissions that go to court. So there's a very small number of people that get treated in facilities, and when patients are in facilities, they're not treated any differently if they're on an involuntary status versus a voluntary status. They have the same privileges, they're treated by the same doctors.
But this is about people who have been released, right? So we're talking about the people who've been released, and I guess my basic question is, why shouldn't we consider collateral consequences once the person's released?
Again, and I think in this case, the illustration is clear that this particular person has not indicated that there's any desire to access any kinds of weapons or apply for any kind of a license for a gun. So
But
I think it's
doesn't have to just
speculative.
it doesn't have to be about guns, and I'd prefer it not to be. I think, just let's talk about the stigma. Let's talk about, guardianship issues. Let's talk about
But again, I'm not sure that I completely agree with counsel that it's always used in that type of situation. You can't access the file, you can't access the orders, you can't walk into a court and ask for a commitment order of a particular patient. You can't even ask if the person was committed. So unless you're involved with the situation, a family member who might know, or you're intimately involved in that particular situation, nobody is going to know that. Nobody is going to be able to access that information.
I mean, you go see say you go see this kid applies to college, he goes to the counselor, he has some mental health issue. Have you ever been, involuntarily committed? And now he has to say, he can't say, yes, but I got that voided because it was a mistake. It's going to come up in this child's life, well, he's now an adult, life. I mean, I don't know if it's a bad thing or a good thing that he has to discuss it, but it's not a non-thing.
But again, that might be treatment related versus, is it gonna prevent him from getting into school? I don't think so. Is it gonna prevent him from getting a job? I don't think so. Again, in that type of situation, I think that would be further care and treatment that it might be relevant, or it might not. I mean, when you get in, if the same person shows up at the facility who has been committed a year ago, I mean, again, what the judge is supposed to look at is what they have in front of them at the time that they're looking at the particular situation. So it's not what they did a year ago, it's what they're doing now. Is there an imminent risk of harm? That's one of the standards that's in front of the court. So I respectfully disagree, having seen these cases and been involved in them for years, that this is really creates a real deterrent to a patient in pursuing their lives and going forward. And I also think that if this court looks at the mootness issues and decides that because of this registry and and potentially the consequences, every case then is going to be able to be appealed, and every case is going to have an appeal. I think that CPCS is going to feel duty-bound to protect the patient's constitutional rights.
Play that out for me in terms of you. You're retained by Simbai Hospital.
Correct.
So, this case comes, and let's assume that, for the sake of argument, say that we say it's not moot, goes to the appellate division. He's no longer in your care.
Right.
What does the hospital do at that point? The person no longer is a patient of the hospital. The matter is remanded for an appellate argument. Does the hospital say, we're going to continue to press it, or we're going to say we don't care anymore?
Well, I think, Your Honor, what we've been doing, I can honestly tell you I've done both, because the number of appeals has increased in the last 5 years. I can give you the numbers for McLean, because I have those numbers, but it's an astonishing number in the last 5 years.
If you've got the number, I'll hear it.
It's 47.
Okay.
So,
but who's counting?
and in the 15, 20 years before then, it was maybe 2. So it's a huge increase.
Is that because people sense there are more collateral consequences?
I don't really know, to be perfectly honest. I think you would need to ask CPCS that question, not so much me. But I have taken that tack that they're gone, and the hospital doesn't really seem to have much more of an interest. Appellate Division was not too pleased with that and decided that they felt it was more appropriate if there was somebody on the other side giving them at least, another viewpoint. So have jumped back in. But I think if every case now turns, I can honestly tell you this is my position, if every case now is no longer moot and is going to be appealed or potentially appealed, and there's going to be even more appeals in the future, that I think that the hospitals would probably at that point say, I can't do it anymore, it's not cost effective, we don't have a continuing interest in these cases. And the other issue with this particular case is the bottom line, regardless of the mootness issue, the legal issue that was behind this case had been decided in the NL case. So I think that, looking at that issue, and I think that's what the appellate division did, was they looked at the underlying issue and said, that issue was dealt with by this body in the NL case, and therefore we don't need to relitigate because this body has now made a decision in the NL case which would apply in this particular case. So I think that they felt like they didn't need to hear it because you folks had already made that decision. So I think on two levels, there's some mootness issues. I think there's mootness on that regard because the legal issue had already been decided.
But it was actually decided in a way that said you should have granted the continuance. So it's.
Well, it said you
it's-
should have granted the continuance unless the court
And meaning
makes
you
a
should have
finding.
granted the continuance, or there was a due process violation, right? Or something to that effect.
And again, it's unclear what the judge made her decision on because she didn't issue any findings and didn't issue anything on the record. She just made a ruling. So you couldn't get to that to determine what she made her. She could have made her decision based in accordance with the NL case, but we don't know that because she didn't do that. So I think that, you know, again, I just want to reiterate that I think that this gentleman doesn't appear to have any, there's no specific evidence that there are any consequences for him with respect to this commitment. He's not indicated he's desirous of getting any kind of a weapon, and the legal issue has been decided by this court.
Do you know whether or not, if it is vacated, it would affect his ability to get a weapon? I mean,
I think it would.
I'm looking at the statute which says you may not have an FID card if you have been confined to any hospital for mental illness. Well, he was confined to a hospital for mental illness. The order was vacated. Do we know how that's been interpreted, how that's played out? And I know the federal statute, 922,
Right.
speaks about, their language is somewhat antiquated, but has been adjudicated as a mental defective,
Well, I think-
or has been committed to any mental institution.
Right. I don't know what mental defective is. No,
Okay, but
I tried to find a
It's the
definition.
latter part that would matter, but he has been committed to a mental institution. I guess I don't know how that the feds interpret that if that order has been vacated.
I would presume if the order's vacated, then there would be an obligation to take him off the list. Based on, I think, if you read the Massachusetts statute, if you go back after 5 years and you're granted that waiver or whatever it's called, you then get taken off the list. So I think vacating a commitment order would potentially allow you to be taken off the list. I think it would.
All right, thank you.
Okay, thank you very much.
All right.